Rule 110, Prosecution of Offenses. Institution of criminal actions shall be instituted as follows for offenses where preliminary investigation is required pursuant to Section 1, Rule 112 by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. For all other offenses, by filing the complaint or information directly with the municipal trial court and municipal circuit trial courts or the complaint with the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provides in their charters. Note: the institution of criminal action shall interrupt the running of the period of prescription of the offense charged unless otherwise provided in the special laws. Complaint or information. The complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appear to be responsible for the offense involved. Complaint defined. A complaint is a sworn statement charging a person with an offense subscribed by the offended party or any peace officer or other public officer charged with the enforcement of the law violated. Information defined. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed in the court. Who must prosecute criminal actions? Crimes of adultery and concubinage shall be prosecuted upon which a complaint filed by the offended spouse, the offended party cannot institute criminal action or prosecution without including the guilty parties if both are alive, nor in any case if the offended party has consented to the offense or pardoned the offenders. Sufficiency of complaint or information. A complaint or information is sufficient if it states the name of the accused, the designation, the offense given by the statute, or acts of omissions or complaint of constituting the offense, the name of the party, the approximate date of the commission of the offense, and the place where the offense was committed. When an offense is committed by more than one person, all of them shall be included in the complaint or information. Rule 111, Prosecution of Civil Action. Institution of criminal actions and civil actions. When a criminal action is instituted, the civil action for the recovery of civil liability arising from the offense charged shall be deemed instituted with the criminal action unless the offended party waives the civil action, which reserves the right to institute it separately or institutes the civil action prior to the criminal action. The reservation of the right to institute separately of the civil action shall be made before the prosecution starts presenting its evidence and under circumstances affording the offended party a reasonable opportunity to make such reservation. The criminal action for violation of Batas Pambansa shall be deemed to include corresponding civil action. No reservation to the file such civil action separately shall be allowed. Upon filing the aforesaid joint criminal and civil actions, the offended party shall pay in full filing fees based on the amount of check involved, which shall be considered as the actual damages claimed. Where the complaint or information also seeks to recover liquidated, shall pay additional filing fees based on the amounts alleged therein. If the amounts are not so alleged but any of these are damages subsequently awarded by the court, the filing fees based on the amount shall be awarded constitute as first lien of the judgment. Rule 112, Preliminary Investigation. Preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to endanger a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except, as provided in Section 7 rule of this rule, a preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. The preliminary investigation shall be conducted in the following manner. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies of the official file. The affidavit shall be subscribed and sworn to before any prosecutor or government official authorized to administer oath, or in their absence or unavailability before a notary public, each of whom must certify that he personally examined the affiants and he is satisfied that they voluntarily executed and understood their affidavits. Within 10 days of filing the complaint, the investigating officer shall either dismiss it if he finds no ground to continue with the investigation, or issue a subpoena to the respondent attaching to it a copy of a complaint and its supporting affidavits and documents. The respondent shall have the right to examine the evidence submitted by the complainant, which he may not have been furnished, and copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and this shall be made available for examination or copying by the respondent at his expense. Objects as evidence need to be furnished to a party but shall be made available for examination, copying, or photographing at the expense of the requesting party. Within 10 days from the receipt of the subpoena with the complainant and supporting affidavits and documents, the respondent shall submit his counter-affidavit and that of his witnesses and other supporting the documents relied upon of his defense. The counter-affidavit shall be subscribed and sworn to and certified as provided in paragraph of this section, with copies thereof furnished by him to the complainant. The respondent shall not be allowed to file a motion to dismiss in lieu of counter-affidavit. The investigation officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from the submission of the counter-affidavits and other documents or from the expiration of the period of their submission. It shall be terminated within 5 days, and within 10 days after the investigation officer shall determine whether or not there is sufficient ground to hold the respondent for trial. In case it is defined as informal and summary investigation conducted by a police conducted by public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant of arrest issued by the court. The inquiry serves to determine whether said person should remain in custody and correspondingly be charged in court. Rule 113. Arrest. Arrest is the taking of person into custody in order that he may be bound to answer for the commission of an offense. Arrest. How is it made? Arrest is made by an actual restraint of a person to be arrested or by submission to the custody of the person making the arrest. No violence or necessary force shall be used in making an arrest. The person arrested shall not be subject to greater restraint than is necessary for his detention. Execution of warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for the execution shall make a report to the judge who issued the warrant. In case his failure to execute the warrant, he shall state the reasons therefor. Arrest without warrant when lawful. A peace officer, a private person may, without a warrant, arrest a person. A. When his presence, the person to be arrested has committed, is actually committing or is attempting to commit an offense. B. When an offense has just been committed and he has a probable cause to believe, based on the personal knowledge of facts or circumstances, that the person is to be arrested has committed it. And C. When the person is to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped being transferred from the one confinement to another. In cases falling under paragraphs A and B, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail and shall be proceeded against in accordance with the Section 7 of the Rule 112. The time of making arrest may be made on any day at any time of the night. The methods of arrest by officer by virtue of warrant When making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and the fact that a warrant has been issued for his arrest, except when he flees or forcibly resists before the officer has opportunity to inform him or when the giving of such information will imperil the arrest. The officer need not to have the warrant in his possession at the time of the arrest, but after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as practicable. When making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and cause the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flees, or forcibly resists before the officer has the opportunity to inform him or when the giving of such information will imperil the arrest. Method of arrest by private person. When making an arrest, a private person shall inform the person to be arrested of the intention to arrest him and the cause of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, or has escaped, flees, or forcibly resists before the person making the arrest has opportunity to inform him or when the giving of such information will imperil the arrest. Right of the officer to break into building or enclosure. An officer, in order to make an arrest, either by virtue or warrant without a warrant as provided in Section 5, may break into building or enclosure where the person or to be arrested is or is reasonably believed to be, if he refuse admittance thereto after announcing his authority and purpose. Bench warrant is actually issued when a person has failed to appear in court on a specific date after receiving the notice or order to appear. Once the warrant is issued, the person is subject to arrest. Rule 114. Bail. Bail is the security given for the release of a person in the custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance. Bail, a matter of right. All persons in custody shall be admitted to bail as a matter of right with sufficient sureties or release on recognizance as prescribed by law or this rule. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court in cities, or Municipal Circuit Trial Court, and before conviction by the Regional Trial Court, an offense not punishable by death, reclusion perpetua, or life imprisonment. Bail when discretionary. Upon conviction by the Regional Trial Court of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. Note: when a person has been in custody for a period equal to or more the possible maximum imprisonment prescribed for those offense charged, he shall be released immediately, without prejudice to the continuation of the trial or the proceedings in appeal. If the maximum penalty to which the accused may be sentenced in desiero, he shall be released after 30 days of preventive imprisonment. A person is in custody for a period equal to more than the minimum of the principal penalty prescribed for the offense charge without application of the indeterminate sentence law or any modifying circumstance shall be released on a reduced bail or on his own recognizance at the discretion of the court. Rule 115. Rights of the accused. Rights of the accused at the trial. In all criminal prosecutions, the accused shall be entitled to the following rights. A. To be presumed innocent until the contrary is proved beyond reasonable doubt. B. To be informed of the nature and cause of the accusation against him. C. To be present and defend in person and by counsel at every stage of the proceedings, from the arraignment to promulgation of the judgment. The accused may, however, waive his presence at the trial pursuant to the stipulations set forth in his bail, unless in his presence is specifically ordered by the court or for purposes of identification, the absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver of his right to the present threat. When an accused under custody escapes, he shall be deemed to waive his right to present all the subsequent trial dates until the custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of the counsel. Rule 116. Arraignment and plea. Arraignment and plea, how is it made? A. The accused must be arraigned before the court where the complaint or information was filed or assigned for trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and asking him whether he pleads guilty or not. The prosecution may call it at the trial witnesses other than those named in the complaint or information. The accused must be present at the arraignment, must be personally entered his plea, and both arraignment and plea shall be made of record, but failure to do shall not affect the validity of the proceedings. When the accused refuses to plead or makes a conditional plea, a plea of not guilty shall be entered for him. When the accused pleads guilty, but he present exculpatory evidence, his plea shall be his plea shall be deemed withdrawn, and a plea of not guilty shall be entered for him. Bill of Particulars. The accused may, before arraignment, move for a bill of particulars to enable him to properly plead and prepare for trial. The motion specify the alleged defects of the complainant or information and the details desired. Rule 117. Motion to quash. Time to move to quash. At any time before entering his plea, the accused may move to quash at the complaint or information. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charged. The grounds of motion to quash. The accused may move to quash the complaint or information or any of the following grounds: that the facts charged do not constitute an offense, that the court trying the case has no jurisdiction over the offense charged, that the court trying the case has no jurisdiction over the person of the accused, that the court officer that the officer who filed the information had no authority to do so, that it does not conform substantially to the prescribed form, that more than one offense is charged except when a single punishment for various offenses is prescribed by law, that the criminal action or liability has been extinguished, that it contains amendments which, if true, would constitute a legal excuse of justification, and that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. Rule 118. Pre-trial. Pre-trial mandatory in criminal cases. In criminal cases recognizable by the Sandigan Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, and Municipal Circuit Trial Court, the court shall, after arraignment, within 30 days from the date the court acquires jurisdiction over the person of the accused, unless shorter period is provided for the special laws or circulars of the Supreme Court, order a pre-trial conference to consider the following: plea bargaining, stipulation of facts, marking of identification of evidence of the parties, waiver of objections to admissibility of evidence, modification of the order of trial if the accused admits the charge but interposes a lawful defense, and such matter, as well as promote the fair and expeditious trial of criminal and civil aspects of the case. Pre-trial agreement. All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel, otherwise they cannot be used against the accused. The agreements covering the matters referred to the Section 1 of this rule shall be approved by the court. Rule 119. Time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial commences within 30 days from the receipt of the pre-trial order. The trial once commenced shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. The court shall, after consultation with the prosecutor and defense counsel, set the case for continuous trial on weekly or other short item trial calendar at the earliest possible time so as to ensure speedy trial. In no case shall the entire trial period exceed 180 days from the first day of trial, except otherwise authorized by the Supreme Court. The time limitations provided under the preceding section shall not apply where special laws of the Supreme Court provide for shorter period of trial. The remedy where accused is not brought to trial within the time limit. If the accused is not brought to trial within the limit required by Section 1, Rule 116, Section 1 as extended by the Section 7 of this rule, the accused of the ground of the denial of his right to speedy trial, the accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with the evidence to establish the exclusion of the time under Section 3 of this rule. The dismissal shall be subject to the rules on double jeopardy. Failure of the accused move for dismissal prior to trial shall constitute a waiver of the right to dismiss under this section. Demurrer to evidence. After the prosecution rests its case, the court may dismiss the action on the ground of insufficiency of evidence on its own initiative after giving the prosecution the opportunity to be heard, or upon demurrer to evidence filed by the accused with or without leave of court. What is demurrer to evidence? It is a motion to dismiss the ground of insufficiency of evidence. It is a remedy available to the defendant to the effect that the evidence produced by the plaintiff is insufficient in point of law, whether true or not, to make out a case or sustain an issue. If the court denies the demurrer to evidence, file the leave of court, the accused may adduce evidence in his defense. When demurrer to evidence is filed without leave of court, the court waives the right to present evidence and submit the case of judgment on the basis of the evidence for the prosecution. The motion for leave of court to file demurrer to evidence shall specifically state its ground and shall filed within non-extendable period of 5 days after the prosecution rests its case. The prosecution may oppose the motion within the non-extendable period of 5 days from its receipts. If leave of court is granted, the accused shall file the demurrer to evidence within a non-extendable period of 10 days from notice. The prosecution may oppose the demurrer to evidence within similar period from its receipts. The order denying the motion for leave of court is to file demurrer to evidence, or the demurrer itself shall not be reviewable by appeal by certiorari before judgment. Rule 120. Judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged, and the imposition on him of the proper penalty and civil liability, if any. It must be in writing in the official language, personal and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of facts and law upon which is based. Rule 121. New trial or reconsideration. New trial or reconsideration at any time before a judgment of conviction becomes final, or the court may, on motion of the accused or at its own instance but with the consent of the accused, grant a new trial or reconsideration. Grounds for new trial. The court shall grant new trial of any of the following grounds. A. That errors of law or irregularities prejudicial the substantial rights of the accused have been committed during the trial. B. The new and material evidence have been discovered which the accused could not could not with reasonable diligence have been discovered and produced at the trial, and which, if introduced and admitted, would probably change the judgment. Ground for consideration. The court grant consideration on the ground of errors of law or fact in the judgment, which requires two further proceedings. Rule 122. Appeal. Who may appeal? Any party may appeal from judgment or final order unless the accused will be placed in double jeopardy. Where to appeal? The appeal may be taken as follows. A. To the Regional Trial Court in case decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court. B. To the Court of Appeals or the Supreme Court in the proper cases provided by the law in cases decided by the Regional Trial Court. And C. To the Supreme Court in cases decided by the Court of Appeals. When appeal is to be taken, an appeal must be taken within 15 days from promulgation of the judgment or from notice of the final order appealed from. This period for perfecting an appeal shall be suspended from the time a motion for new trial or reconsideration is filed until notice of the order overruling the motion has been served upon the accused or his counsel, at which time the balance of the period begins to run. Rule 124. Procedure in the Court of Appeals. In all criminal cases appealed of the Court of Appeals, the party appealing the case shall be called the appellant, and the adverse party the appealee, but the title of the case shall remain as it was in the court of origin. Appointment of counsel de officio on appeal. If it appears from the record of the case as transmitted that the accused is confined in prison, is without counsel, the party on appeal has signed the notice of appeal himself, the clerk of court of appeals shall designate a counsel de officio. The Court of Appeals may reverse, affirm, or modify the judgment and increase or reduce the penalty imposed by the trial court, remanded the case to the Regional Trial Court for new trial or retrial, or dismiss the case. The Court of Appeals shall have the power to try cases and conduct hearings, receive evidence. Trial in CA must be completed with 3 months unless extended by the Chief Justice. Note, there are 23 divisions in the CA. 3 divisions are found in Cagayan and under 3 in Cebu. Each division has 3 justices, consisting of chairman, senior member, and junior member. Rule 125. Procedure in Supreme Court. When Supreme Court angba is equally divided in opinion or necessarily majority cannot be had on whether to acquit the appellant, the case shall read deliberation or the judgment or conviction of the lower court shall be reversed and accused acquitted. Note, the second motion for consideration is not allowed in trial courts and CA, and second or third MR may be allowed but with leave of court. Rule 126. Search and seizure. Search warrant is an order in writing issued in the name of the people of the Philippines, signed by the judge and directed to the peace officer, commanding him to search for personal property described therein and bring it before the court. A court where application for search warrant shall be filed. An application for search warrant shall be filed with the following. 1. Any court with those territorial jurisdiction a crime was just committed. 2. For compelling reasons stated in the application, any court within the judicial region where the crime was committed as if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. Personal property to be seized. A search warrant may be issued for the search and seizure of the personal property, subject of the offense, stolen or embezzled, and other proceeds or fruits of offense, or used or intended to be used as the means of committing an offense. Requisites for issuing search warrant. A search warrant shall not issue except upon probable cause in connection with one specific offense to be determined whether personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may be produced, and particularly describing the place to be searched and the things to be seized, which may be anywhere in the Philippines. The right to break door or window to effect search. The officer, if refused admittance to the place of directed search after giving notice of his purpose and authority, break open any altar or any door or window of a house or any part of the house or anything therein to execute the warrant or liberate himself or any person lawfully aiding him when unlawfully detained therein. Search house, room, or premises to be made in presence of 2 witnesses. No search of house, room, or any premises shall be made except in the presence of the lawful occupant thereof or any member of the family, or in the absence of the latter, 2 witnesses of sufficient and discretion residing in the same locality will be okay. Time of making search. The warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which the case a direction may be inserted that it may be served at any time of the day or night. The validity of search warrant. A search warrant shall be valid for 10 days from its date. Thereafter it shall be void. Search incident to lawful arrest. A person lawfully arrested may be searched for dangerous weapon or anything which have been used or constitute proof in the commission of an offense without a search warrant. Motion to quash a search warrant or to suppress evidence. Where to file? A motion to quash a search warrant and or to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued the search warrant. However, if such court failed to resolve the motion and a criminal case is subsequently filed in the court, the motion shall be resolved by the latter court.